Welcome to EU Privacy for All, Session 71 on GDPR, Implementing Acts, Article 87. Neither the Parliament nor the Council suggested new modifications or additions with regard to Article 87. European Parliament suggested the deletion of the third paragraph. In the end, the final draft of Article 87 on the committee procedure laid down that the Commission shall be assisted by a committee within the meaning of the regulation adopted in 2011 regarding the implementing powers of the Commission. Article 5 and 8 were particularly stressed. The adoption of implementing acts within GDPR is framed by the Article 5 of the regulation adopted on the 16th February 2011 regarding Commission's exercise of implementing powers. The key takeaway from this provision is that a qualified majority will adopt in the end or not the implementing acts proposed by the Commission. That is to say, at least 55% of the members of the Council, comprising at least 15 of them, and representing at the very minimum 65% of the population of the Union. Where the committee delivers a positive opinion, the Commission shall adopt the draft implementing act. If the committee delivers a negative opinion, the Commission shall not adopt the draft implementing act. Instead, the Chair may either submit an amended version of the implementing act within 2 months or submit the draft implementing act within 1 month of such delivery to the appeal committee. Where no opinion is delivered, the Commission may adopt the draft implementing act. The Commission shall not adopt the draft implementing act where, for instance, a simple majority of the component members of the committee opposes it. Getting back to GDPR, let's notice that Recital 118 makes really clear that the compliance with the regulation also covers compliance with delegated and implementing acts adopted in accordance with the regulation. Recital 130 reminds of those implementing powers to be exercised in accordance with Regulation 182/2011. A long list is provided in Recital 131 on the examination procedure to be used regarding different provisions in GDPR. Recital 132 also makes clear that the Commission should adopt immediately applicable implementing acts where available evidence reveals that a country would not ensure an adequate level of protection in order to stop data transfers to this country or organization. Article 26(2)b also tackles the fact that Article 87 will apply to adopt implementing acts regarding standard contractual clauses for the contracts between processors and controllers. It all goes the same regarding Article 38(4) and Codes of Conduct. Technical standards for certification mechanism, adequacy decisions, and also turning down adequacy decisions that were adopted but where a country or an organization no longer ensures an adequate level of protection. Appropriate safeguards regarding standard data protection clauses adopted by the Commission or by a DPA. In Article 43(4), it is reminded that the Commission may specify the format and procedures for the exchange of information between controllers, processors, and supervisory authorities using implementing acts. It shall do the same regarding format and procedures for mutual assistance between DPAs and between DPAs and EDPB. Those implementing acts for the exchange of information by electronic means between authorities and the EDPB shall be adopted in accordance with the examination procedure laid down in Article 87. And finally, the EDPB shall forward its opinion to the committee referred to in Article 87 and make them public. In Article 31 of the directive, entitled The Committee, the implementing powers of the Commission are currently framed. The Commission shall be assisted by a committee composed of the representatives of the Member States and chaired by the representative of the Commission. The Commission will be submitting to the committee a draft of the measures to be taken, and an opinion will be delivered by the majority as framed in the treaties. The Commission shall adopt measures applying immediately. However, if these measures are not in accordance with the opinion of the committee, they shall be communicated by the Commission to the Council. In such a case, the Commission shall defer application during 3 months, and the Council, acting by a qualified majority, may take a different decision within 3 months. What should accountable data controllers and processors get prepared for? First, knowing that complying with GDPR also means complying with delegated and implementing acts adopted on the basis of the GDPR. The topics to be framed by those implementing acts are listed in the regulation. It mainly consists of standard contractual clauses between controllers and processors or processors, codes of conduct, certification mechanisms, adequacy decisions, standard protection clauses, formats and procedures for exchange of information between controllers, processors and DPAs for BCRs, or in the frame of the mutual assistance between DPAs and data protection authorities and European Data Protection Board. As set in the Regulation 182/2011 of 16 February 2011 on Commission's exercise of implementing powers, a qualified majority should adopt implementing acts, that is to say, more than 55% of the members of the Council, comprising at least 15 of them and representing at least 65% of EU population. The question triggered now is knowing whether the Commission will be supported in the set of implementing acts that it will be willing to adopt.